Thank you. Mr. O'Neill? And then we'll ask questions at the conclusion of all three presentations.
Oh, there's a rumor that if we do this, then it will come to the next. Nope.
We'll try it. We'll get
Wait
it.
a second.
Okay, thanks.
Help is on the way.
Thanks. Okay. Okay, thanks. First, Chair and members, thank you for the opportunity to address you today. I'd like to explain, hopefully briefly, the nature of the work that I was asked to do by the Governor and the results of the work that I've done over the last year. I started working on this task to take a look at the PUC to see if there are ways to improve its efficiency, effectiveness, transparency, and accountability with no particular focus on the problems that have appeared in the papers recently. That all post-dated the work that I started. The concern was at the time that I began that the PUC has a huge impact on the state of California. It affects every resident, business, industry. It regulates a huge percentage of our economy either directly or indirectly by the effects of its decisions, policy decisions, and rate decisions on those entities. And that it could do the work that it does better. And one of the concerns was that many proceedings at the Commission just take too darn long. In 2014, the average application proceeding took about 1.4 years to decide. The average investigation proceeding took about 4.9 years to resolve. And the average rulemaking proceeding took 4.5 years to resolve. So the feeling was a relook at how the PUC does what it does is really in order to improve its efficiency, effectiveness. And then with all the emails that came out about improper ex-parte communications and so forth, the task broadened a bit to include some additional factors and place higher priorities on those. And those included transparency, accountability, and equity. Many of the conclusions that I reached and that are discussed in the paper that I believe you have copies of are similar to some of the findings that Strumwasser and Wucher reached. I reached them in a different way, though, because my task was really looking at things from a different perspective. My focus was looking more broadly at the PUC's operations on a broader basis to try to improve not only its efficiency and effectiveness, but really looking at the end products. How can we get safer utilities, services, and facilities? How can we get those facilities provided in a more environmentally acceptable manner and with more resiliency and with more reliability and at lower costs and lower rates with better impacts on the economy? So I was taking a much broader look at how the PUC does what it does to improve the quality of the decisions as well as the timeliness of the decisions, and only secondarily looking at these issues regarding transparency and accountability. But as you'll see, many of the findings that I reached are consistent with the findings of Strumwasser and Wucher. So let me jump to the key findings. Over the last year, I reviewed a lot of internal data on PUC proceedings, looked at a lot of different academic literature, looked at a lot of different studies that had been done about the PUC and about other state and federal agencies to try to see where the opportunities are for improving its efficiency, effectiveness, transparency, and accountability. And a couple of things kept coming up over and over again in a lot of the academic studies and also in reviews that I did of what the PUC does in processing the work that it has and the proceedings that it has before it. And those things were problems with communication and information flow within the agency. That was a very significant concern in a lot of the academic literature about organizations that aren't as successful as they could be and about significant problems that have arisen with regard to both government and private enterprises. The other item that came up very prominently was problems with what's referred to as governance or enterprise management. And that refers to really the kind of executive level oversight of an organization, what its programs are, its priorities, its proceedings, how it does its business. Those two factors seemed to be popping up over and over and over again when I read different literature about organizations that were having problems and didn't succeed where they should have. They also came up over and over and over again when I talked to people at the PUC, both at the commissioner level, at the division director level, and at the working level. Problems with communication and overall management enterprise level management, senior level management cropped up over and over again. It's my view that those factors really permeate nearly every aspect of the PUC's work, and they cause problems with nearly every aspect of what the PUC does in virtually every industry it regulates and with respect to many of the work products that it produces. I don't think the agency can come close to achieving its potential until those two issues are addressed. So let me talk first about those two problems. Then I'll talk briefly about how they relate to ex parte issues, and then I'll discuss briefly some of the recommendations that I came up with. Okay, information flow. This is characterized by a lot of different things. Frequently, there's a problem at the executive level. There also are problems with what are called organizational and informational siloing, where information is within the organization that's essential for it to succeed, but it doesn't get to the right place. That's also described as problems with information flow. Information flow may not match the decision-making process, so that the information filters up through the organization in some manner, but not to the right people that need that information in order to make decisions. It also produces something that's referred to in the academic literature as information dissonance. And that is frequently one of the causes of flawed decision-making in an organization. And that's where you have different entities or individuals within the organization responsible for making decisions that have the information they need, but they interpret it in very different ways. And the best illustration of this involves the NASA Challenger failure. And I want to just briefly discuss this because there's some parallels between what happened there and what's happening at the PUC now. The immediate precipitating causes of that failure was something that was quickly identified as problems with what are called the O-rings on the solid rocket boosters. They had experienced damage on prior shuttle launches. It was known that they tended to burn through partially on some launches, but not all launches. When the shuttle exploded, the Challenger exploded, the engineers and the other analysts quickly jumped on that as the cause. Former Professor Richard Feynman decided that that was only the most obvious cause, but there was a deeper root cause. His view was the real problem with NASA wasn't the O-rings, it was the decision to launch the shuttle under the conditions that existed. So he did more work trying to look into that and wasn't really supported all that well by the other members of this independent review commission that he was on. One of the things he did was he asked the engineers what they thought the risk of a catastrophic failure of the shuttle was. And the engineers that he spoke to that were familiar with the solid rocket boosters all came up with about the same estimate, 1 in 200. He asked the same question of the managers, and this is after the Challenger exploded, what they thought the probability of a catastrophic failure of the shuttle was. Their estimates were also almost all in the same range, but they were 1 in 100,000. The engineers and the managers viewed the risk of catastrophic failure dramatically different, even though they were all aware of the prior problems with these O-rings and the fact that they'd burned through. The real problem was a communication problem. The engineers at NASA viewed the problems with the O-rings as a safety issue. The managers viewed it as a maintenance issue. The net result was a flawed decision to launch, and the Challenger exploded. The CPUC has similar communication deficiencies. There are all kinds of deficiencies within the organization. The Bagley-Keene Act impairs discussions between commissioners outside of public business meetings. And as Mr. Strohmasser noted, they don't spend a lot of time in the public business meetings. And in those meetings, there's actually very little lively discussion and debate of issues among commissioners. The communication barriers also exist between the executive level and the management level below that, and also at the working level. There are all kinds of examples where we see situations where the staff views the commissioners and the management as more interested in information coming from other sources, like outside parties, than from the staff themselves. We see problems within divisions and between divisions. In many cases, you have technical experts that pretty much stay within their own division. Even though they're in the same professional field, they may not communicate much with others in the same field. So there isn't much cross-fertilization from one industry or one division to the other. Those information problems have led to significant problems within the Commission and some significantly flawed decisions, just like occurred at NASA. The best example is the CPU's natural gas safety program and the San Bruno accident. I looked at the independent reviews of the San Bruno accident very carefully, and they really focused on what looked like something pretty much analogous to looking at the O-rings. They looked at problems with the PUC's oversight and problems with PG&E. Some of those reviews, though, I think stopped at a level that's a little too shallow, at least with respect to the PUC. Because what they found with the PUC was there were a number of problems with the PUC's oversight, but there were a lot of things that contributed to those problems that were really not dealt with and not clearly identified, and not identified clearly enough to really adopt the right remedy. The best example is if you look at what SED was doing at the time, the Safety and Enforcement Division. They were well aware of the fact that they had too few inspectors. They couldn't possibly inspect all of the high-pressure gas transmission line they were supposed to inspect, along with 3,200 small mobile home parks and propane systems, and all the distribution systems throughout the state. They had something like 18 inspectors. That may be rounding up. They couldn't possibly inspect all those facilities. They knew there was a problem there. They also knew that federal regulations had changed. They needed a different type of training in order to effectively implement these new federal regulations. The only way they could get that training was in Oklahoma. They didn't have the out-of-state travel budget to do it. They didn't have the out-of-state or the training budget to do it, so they didn't get the training. They knew that too. There were lots of things the SED staff knew that they should be doing differently. They didn't have the resources to do it. The PUC management didn't really adequately pursue remedies to those problems. They viewed those kinds of problems as typical kind of administrative problems. That's state government. The SED people viewed those issues as safety issues. They weren't getting the training. They didn't have enough people. They were going to do the best job they could, but they knew that there were safety implications for what they were doing. The result, SED didn't oversee adequately PG&E's operation and maintenance of its gas transmission system, and the pipeline exploded. Now here's the real troubling part. After the Challenger explosion, NASA didn't learn the lesson about information flows. It took another shuttle explosion for them to figure out that the problem wasn't just the O-rings. The problem was they weren't dealing with information and assessment of risks in a proper way. And the PUC could be in the same situation today. The PUC needs to deal with these internal information flow issues so that they can understand the information and properly assess it if they're going to do the business that they're doing in the right way and avoid a repeat of something like the San Bruno incident. Okay, now, as far as enterprise management goes, we have the same kinds of problems that were identified in a lot of the academic literature about industries and organizations that failed. There was a real interesting book I read about the financial crisis, what financial firms succeeded, what financial firms failed. The key factor that distinguished the companies that succeeded from those that failed had to do with enterprise management, how the organizations were managed, whether they encouraged what was called constructive dialogue so that information flowed up from the working level to the managers so they could act on it as well as down, or whether there was some impairment there. The problems with enterprise management are related to the problems with the information flow. And the PUC has significant problems with its enterprise management. Right now, today, it's trying to tackle that problem. But about 3 or 4 months ago, before the commission tried to form these 2 commissioner committees to oversee senior level management, business enterprise type functions, it had no system whatsoever for enterprise management. There was no strategic plan. There were no effective metrics. There was no way to really monitor metrics to see whether the commission was succeeding or failing, and if so, what needed to be done. The staff had no common sense of mission. Many of the working groups within the commission were more loyal to their own working group and what their working group thought was in the best public interest than they were to the agency's overall mission and structure. So these kinds of things need to be remedied. Okay, there are a couple things that can be done. Many things can be done by the commission on its own initiative, and the commission is already undertaking a number of steps to address these problems. There are others, though, that need to be addressed through legislation. One of which I identify in my paper is Bagley-Keene reform. I'm not going to talk about that in detail today because we're focusing on ex parte, and that is the second thing that I think needs attention. And Mr. Stromwasser and Ms. Palmer already discussed that with you. I have a slightly different view on what the solution should be, but I think that's a critical reform. And here's how that relates. It relates to the information flow and the enterprise management because the ex parte process has become such a big part of the PUC's way of doing business, it's tended to drive a significant wedge between the decision makers, the commissioners and the commissioners' advisors on the fifth floor, and the rest of the staff. And that has created this dynamic where the staff rarely feels like they're on the same team as the commissioners. When they speak to commissioners, it's typically in a context where the commissioners are challenging the staff because of information they've heard from some other outside source. The staff people come away with the feeling that the commissioners and the advisors don't trust their advice and analysis. And you get this situation where people don't offer the kinds of advice and recommendations that they might if they felt that their input was valued. So this is a real critical problem, and it contributes to the information flow problems throughout the organization, and it contributes to the enterprise management problems because the commissioners, the senior managers are not getting all the information, and they're not interpreting it necessarily in the way that I think it needs to be interpreted. So what do we do about this? I think the first thing we need to do is take a hard look at the ex parte rules with the goal of making them simpler and easier to administer, and with the goal of making sure that there is some mechanism put in place that will serve the same purpose that commissioners have relied on ex parte communications for in the past. The parties to PUC proceedings currently feel like they need to use ex parte communications in order to speak directly to commissioners and let their views be known. The commissioners, on the other hand, also feel like they need to hear from the parties to understand what the parties' real concerns are. We've got to find a way to revise the ex parte rules that includes a mechanism to provide that same kind of information flow that the commissioners have used ex parte meetings for in the past, that doesn't have the same flaws, lack of transparency and reliability that Mr. Stromosser and Ms. Palmer referred to. So I think the way to do it is to change the fundamental structure of the statutes dealing with ex parte communications to use two different categories of proceedings rather than three. An adjudication category that would cover quasi-judicial proceedings, proceedings in which there are hearings with cross-examination that have a judicial nature and that focus on and decide individual rights of individual companies and customers. Secondly, I would use a quasi-legislative policy category to cover everything else that's of a broader policy nature, where you're dealing with industries as a whole or large customer classes, where the action the Commission is taking and the issues before them are more like issues that come before the legislature. Those are more forward-looking proceedings. And I would keep the rules very simple. Though that scheme is similar to the scheme used by most other state and federal agencies, and it's also similar to the scheme that's used for judicial review of PUC proceedings. The courts use a standard of review that's different for adjudication-type proceedings than policy-type proceedings. They just have two different standards. I would use the same standards for governing ex parte communications. Once those categories are set up, I would have a simple rule that bans unconditionally ex parte communications in the quasi-judicial adjudication proceedings. And that would include rate-setting proceedings involving individual rates for individual utilities. So that would be a significant strengthening of ex parte restrictions with respect to those proceedings. I would permit without reservation, without restriction, ex parte communications in the policy-related proceedings, the quasi-legislative issues that involve broad issues affecting an entire industry or broad classes of customers. And the reason for that is because I think the Commission needs as much information as it can to deal with those policy issues. And in many cases, the parties before a proceeding at the PUC involving policy issues don't necessarily represent all the parties affected by the PUC's decisions. Frequently they don't. You'll have a number of reasonably well-financed parties come in that are well-equipped to let their views be known. There'll be many other parties that are potentially affected by those broad policy issues that don't have the same financing, that don't have the same experts, that don't have the same attorneys, they don't have the same ability to let their views be known. I would keep the rules liberal and simple. The simplest way to do it is to treat those proceedings like legislative type proceedings and let the ex parte communications go forward, but only in those quasi-legislative policy type proceedings. I'd also impose a duty on decision makers as well as parties to disclose improper ex parte communications and adopt meaningful sanctions for violations of the rules. The other important provision, I would also add, and I'm not sure this is the perfect way to do it, but there needs to be a way to do it. I would require the Commission to hold some kind of an en banc hearing before a majority of the Commission at the conclusion of every proceeding, probably after the proposed decision is issued. That way, parties to the proceedings would have an opportunity to speak directly to commissioners. Commissioners would have an opportunity to hear directly from all the parties, but it would be in an open forum. It would be in an open forum where everybody could hear the arguments that every other party was making. And I would require the Commission to give the parties enough time to reasonably let their views be known, not 5 minutes. Give them a reasonable amount of time. It would take more of the Commission's time to have an en banc of that nature, but you'd save a lot of time by eliminating all the individual ex-parte meetings that mechanism would replace. So I think that's a critical element if you're going to avoid the problem that Mr. Day pointed out. If you just restrict ex-parte communications and don't have some other mechanism to allow these parties that are infrequent interveners, that don't have the resources of the utilities to speak directly with the commissioners and let their views be known, you're going to inadvertently be advantaging the utilities, and that's clearly not the intent. And the other big parties are professional interveners, and that's clearly not the intent of ex-parte reform. What you want to do with ex-parte reform is increase transparency, increase accountability, increase equity, make sure the process is fair, not advantage some parties over others. Thank you.
Thank you. I wanted to give the committee members an opportunity to ask questions before we get to public comment, but I do want to thank both of you, all three of you for your presentations. Mr. O'Neill, your emphasis on information flow and Bagley-Keene is timely, given a lot of the reform efforts that we've been talking about in this committee and throughout the building. And Mr. Stromwasser, I've been telling folks, and I know there's a lot of members who are watching or listening to this in their offices, I've been telling your report's a big one, but I've been telling people that the executive summary, as well as the recommendations, and I believe it's part 4 or so, are, I think, should be mandatory reading for those folks who are interested in oversight. Are there any questions from any of the committee members? Okay, I wanted to ask a few. Again, Mr. Stromwasser had that section on his recommendations, and Mr. O'Neill ended his presentation with recommendations. Ms. Palmer mentioned some as well. A lot of recommendations. Are there some that you think are sort of more important or more timely than others in terms of getting at the transparency and accountability, but also in terms of, shouldn't say the larger question, but the other question of sort of transforming the culture of the organization? It's a question open to all three of you.
I'll give start. We think that the most important thing is to channel information back into the Commission itself, into their regular processes. They have the tools already to avoid the need for ex parte communications, not by ignoring parties' views, not by ignoring the public, but by using existing structures. And the first step, frankly, is, and this is one of our recommendations, the Commission itself ought to be meeting much more frequently than once every 2 to 3 weeks. Because if you tell them you can't have ex parte communications and you're only going to meet for 50 hours a year on everything before you, you are essentially shutting down all forms of communication, and we're not in favor of that. They have plenty of ways, if they are compelled to go cold turkey on ex parte communications and simply to bring all of those comments into a public forum. And then you do have the opportunity for other people to hear what's being said, and for the cleansing antiseptic effect of light to reveal exactly who is telling the truth and who is not telling the truth, what is supported by the evidence, what isn't supported by the evidence, what are the consequences that can actually be proven on the record and what are not. So if the legislature will help us by closing off those ex parte communication lines, and then the Commission steps up and uses its current powers to substitute the appropriate channels, that's the most important thing that can be done.
I have a little different take on this. I think, I have 36 plus years of experience at this. I worked as a commissioner's advisor when I was a young lawyer. I worked as an administrative law judge. I've worked as a private lawyer. I've been engaged in ex parte communications and tried to figure out ways to represent small clients. My view is that one thing you have to realize is over that period of time, I think there is one commissioner that's been appointed to the commission that didn't entertain ex parte communications, and that's about it. One. Every single other commissioner of whatever political view found ex parte communications important to one degree or another. And there's a reason for that. I think they've been desperate for information about all these complicated proceedings that are before them. Every year, the Commission decides something on the order of 500 formal proceedings. At any given time, they have something like 300-plus formal proceedings pending before them. They have lots of other informal things going on, and they have a bunch of programs to administer in addition to that. There's no way they can keep on top of all that. And as Mr. Strohmasser pointed out, the way the Commission's set up right now, they don't even have easy access to the record in their own proceedings. I tried to find a copy of an exhibit that was cited in a decision recently. They cited it by exhibit number. I said, I need to take a look at that. It's got some information pertinent to what I'm looking at. We tried to get a copy of that. We couldn't find it. We went to the formal files. We got the record out of the formal files. It took a day. We looked at the formal files. All the exhibits are numbered differently than they were referred to in the decision. Now, imagine if you're a commissioner trying to, look into a complex issue and you're supposed to vote on it 2 or 3 days from now. You can't possibly, go through the record in any kind of detail. You don't even have easy access to it. The exhibits aren't very easy to find. The hearing transcripts aren't that easy to find. And there's way too much material. You don't have the resources to do that. So they're desperate for information. So how do they get that information? Unfortunately, today, I think too much reliance is placed on these private ex parte meetings, and that creates the appearance of unfairness and impropriety, even if there isn't any. Even if all the commissioner's doing is saying, tell me where in your brief you mentioned this issue, or which issue in your brief is the most critical that we really need to focus on. If that's all that's going on in an ex parte meeting, nobody else knows that, so they're suspicious. But the commissioners are just desperate for information. So my feeling is this, and they want to reach better decisions in a collective, collaborative way. They've got problems with the Bagley-Keene Act restricting discussions among commissioners' offices, so it's hard to rely on other commissioners' offices to work collaboratively. They can't under the law very easily, and so they don't. The first thing I would do to really reform the PUC is combine some ex parte reforms to get rid of that wedge that's been driven between the working level staff and the commissioners with some sensible, prudent, limited Bagley-Keene Act reforms. So you can have more discussion among commissioners. The commissioners and their staffs can work more collaboratively. They can, as a group, get a better handle on all this evidence and information before them. And you get more communication and improved communication flow between the working level staff, especially the advisory people, and the commissioners. And that I think would make a very significant improvement within the commission overall. But you can't just cut off the information flow from the parties by adopting strictly judicial type standards in proceedings, many of which are not conducted in a formal way and involve policy issues. I think that's a mistake. It would go the wrong direction.
Great. Thank you. Very helpful. I'm not sure when in the afternoon you all three of you arrived, but we have been looking at different reform bills in this committee. Downstairs, I had another bill, 1023. There's a good 5 or 6 bills. I have 2, Mr. Leno, Mr. Wesso, Mr. Hill. Hill has one as well. To the extent that you're aware of some of our efforts, or do you think we're on the right track? Are we missing some points? And also, and this is a separate question, just as important, but from the perspective of a group of legislators who are very much interested in providing oversight, what advice for us do you have? So, again, 2 questions in terms of legislation, but also in terms of long-term oversight. What are we missing out on? What do we need to be doing?
Yeah, let me answer the second one first, because I think it's really important. The PUC is a constitutional agency, but the legislature has incredible authority to, vest the PUC with additional authority that's not currently in the law, and you can mold that authority. And there's a wonderful thing about the PUC is it is subject to and has much broader authority than many other state agencies, is that it has broad preemptive authority where that's necessary and appropriate. It also has a form of judicial review that allows prompter and more definitive judicial review. It's in the Court of Appeals and the Cal Supreme Court. It can act more definitively. more decisively, and it can act more broadly. And the legislature can use that constitutional power and its own power over vesting the commission with authority to do what you think it should be doing in terms of policy. And you can exercise that, I think, in a prudent way to improve the functioning of the agency and to define the policies that you want the PUC to pursue. The PUC is an agency that is responsive to the legislature and the governor. So, I mean, the problems with the PUC are not just the PUC's problems. They're problems that the governor shares and the legislature shares. So I think all the legislation, I think, seems to me to be very well intended. I think you've got some good, ideas that all the bills seem to me to be motivated in the right way. But I think there's some details that are a bit problematic. For example, none of them right now. The Hill bill originally had a provision that did deal with the Bagley-Keene Act issues in a kind of limited way, but it would have increased to some degree the ability of commissioners to at least discuss matters without reaching a collective consensus or voting outside of a public business meeting. That provision was lost when provisions were merged into SB 660. So it's not in the current SB 660. But that was, I thought, a very good idea. It would have helped the internal dialogue and the ability of the commissioners to act collectively. Another provision that I think is problematic, though I'm not going to cover everything, but I just want to give you an idea. There's some proposals to expand the individuals within the commission that are defined as decision makers for purposes of ex parte rules. That would mean that communications from outside parties with those individuals would either be prohibited or require reporting, the same as PUC commissioners. I think that's probably well intended, but would have very bad results. It would just push down the level within which the kinds of communications occur today to a lower level within the agency. So you would have a lower level of management effectively receiving those communications and getting information that the more senior management and the commissioners don't have. And I think that would be a way to kind of, allocate responsibility and authority in a way that you probably don't intend. And it wouldn't accomplish too much. So there's some things that I think are well intended that could be tweaked and improved. So I hope we have an opportunity to work with the authors of all the bills you mentioned to see what can be done to make them as constructive as possible.
Let me just respond briefly. We have not studied each of the bills, and I don't propose to talk about each of them. But a couple of things that Mr. O'Neill said, which I generally agree with, should I think be tempered. The PUC is a wonderful agency, and it is an important part of American history. It was when it was created in 1911. It was the crowning achievement of Hiram Johnson's first year as governor. And it set the standard for lots of folks. And it is a constitutional agency, and a lot of that stuff is true. But there is a real tendency on the part of the Commission to think that they are an island unto themselves. I've represented lots of agencies that are subject to the Bagley-Keene and the Ralph Brown Act, Public Open Meetings Acts. Every one of them feels put upon to have public meetings. Every one of them does. And for the PUC to say, well, we've got Constitution and history, and those strike me mostly as distinctions without differences. My view is that, like the ex parte question, the Bagley-Keene question has to begin with, have you yet tried to make your public meetings work? And this is a point that was made by the Attorney General in the Little Hoover Commission. Commissioner Florio appeared before the Little Hoover Commission and said, look, here's all the problems why we can't get any of this information, and we don't hear any of it. And Ted Prim for the Attorney General appeared and said, wait a second, have you even tried? You only meet occasionally. You haven't even tried to make public meetings work. And so as to all of these issues, the ex parte and the other procedural issues, it seems to us that the first step is let's have more meetings, let's spend more time in the public. This is a commission. If they announce tomorrow that in 2 weeks they're going to have a hearing on distributed generation, they could have Nobel laureates in front of them. This is an organization which, if they wanted to have a discussion about what really does a utility need economically, they could have a panel of the finest economists in California, the finest economists in the United States. They ought to be having those discussions in the public sector.